Hey, good morning. I'm Commissioner Cindy Jeffries, and I am just going to do the roll call this morning and do an opening statement to address the committee. And then Brady Roberts will take it from there to facilitate this morning's session. So with that, let's get going with our roll call. Accrediting agencies, we have Jamie Studley as primary.
Good morning and happy Friday.
Good morning. And Dr. Laura Racer King.
Good morning.
Good morning. Civil rights organizations and consumer advocacy organizations, Carolyn Fast.
Good morning.
Good morning. And Jaylon Herbin.
Good morning.
Good morning. Financial aid administrators at post-secondary institutions, we have Samantha Veeder.
Good morning.
Morning. And David Peterson.
Good morning.
Good morning. Four-year public institutions of higher education, Marvin Smith.
Morning.
Morning. And Deborah Stanley as the alternate.
Morning.
Morning. Legal assistant organizations that represent students and/or borrowers. We have Johnson Tyler as primary. All right, we'll circle back to Johnson. He may not be here yet. And Jessica Renucci as the alternate. Good morning. For minority serving institutions, we have Barry as the primary, who will not be joining the committee today. So Ashley Schofield, the alternate, will be at the table all day. Ashley?
Good morning, everyone.
Morning. Private nonprofit institutions of higher education, Kelly Perry as primary.
Morning, everyone.
Emmanuel Gilroy as alternate.
Morning, everyone. Happy Friday.
Morning. Proprietary institutions of higher education, Bradley Adams.
Good morning.
Good morning as the primary, and Michael Lanouette as the alternate.
Good morning.
Morning. State General Adam Well is the primary.
This is Adam Welly. Good morning.
Good morning. And Yael Shavit is the alternate.
Good morning.
Good morning. State education executive officers and state authorizing and/or state regulators of institutions of higher education and/or loan servicers. Debbie Cochran is the primary.
Good morning.
Good morning. And David Sokolow is the alternate.
Good morning.
Good morning. Students and student loan borrowers, we have Ernest Izuego as primary.
Good morning, everyone.
Good morning. Carney King as the alternate. Look like Carney is with us yet. We'll circle back. Two-year public institutions of higher education, Dr. Ann Kress.
Morning.
Good morning. She is the primary, and Jordan is the alternate.
Hey, Friday. Good morning.
Happy Friday. Good morning. U.S. military service members, veterans, or groups representing them. Travis Hoare is the primary.
Good morning, everybody.
Morning. And Barmak Nassarian is the alternate.
Morning.
Okay. For civil rights, the primary is Amanda Martinez.
Good morning.
Good morning. The General Counsel representative sitting in this morning is Donna Mangold. Morning. Good morning. And the for the department is Gregory Martin.
Morning.
Good morning. In addition to that, we have two esteemed advisors. David McClintock is a compliance auditor with experience auditing institutions that participate in the Title IV HEA programs. David?
Happy Friday, everyone.
Good morning. And Dr. Adam Looney is the advisor for labor economic or an individual with experience in public research, accountability, and/or analysis of higher education data. It doesn't look like Dr. Looney is with us. I'm just going to circle back to see Johnson has now joined the table.
Sorry for being late. Hello.
No worries. No worries. And has Carney King joined us? It doesn't look like Carney has. So that completes roll call. Did I miss anyone? Oh, it's a good day. So with that, I just want to take a few minutes of your time to address the committee on what our agenda is and the expectations for today as we go into the break time, which would be the final break before the third and final session. And we appreciate all of the hard work that this committee has done both this week and the last session and in between. There remains important work to be completed today, and that being the completion of changes of ownership and change in control issue paper, as well as the 9010 issue paper. The department desires to gather as much information from this committee as possible for consideration going into the period before the final session in March, as they work through their potential amendments to the currently proposed text based on your feedback and your new proposals. In an effort to facilitate the committee's ability to convey to the department as many of your significant concerns and or proposals on the changes in the amended text before you for these two documents, we are asking the following. Per the protocols that you all agreed to, negotiators' 3 minutes should be used only to relay new concerns and offer any new proposals to change that would help get you to consensus in week 3. We ask that the time not be used to restate previously stated concerns, revisit already discussed texts or sections, items not on the table for this negotiated rulemaking, or to express support for something already stated. The intent here is to try to help you focus on the changes that the department has made in the text, the 2 issue paper text before you today. We also want to encourage you to continue to utilize the chat to express your support and for questions. We also encourage you to follow up with written proposals as soon as possible to the department, which can be redlined regulatory text, bullet point documents, etc., and preferably you will submit them in a Word format for their consideration. Questions may also be placed in the chat, as the department may not be able to provide an immediate answer to them. They will strive to address them at a later date and or consider them for their final set of proposals. So the questions that you have are still important to submit, because even if they can't get an answer to you right away, that is something that they are going to be utilizing in considering amending any final text that will be sent your way. We will be assisting you with the above focus to keep you moving through the changes in the text before you. The intent is not to limit dialogue, but it is instead intended to help you best utilize the remaining time in this session to enable a process following the protocols to concisely articulate concerns for the department to hear and take into consideration in the time before that final session. So it is our expectation that you will complete the changes of ownership issue paper as well as begin the 9010 review this morning. And the 9010 will be picked up and completed this afternoon. Before we close out the session this afternoon, whether we have time before public comment or it has to be reserved till public comment is reserved, we ask that you not immediately leave the meeting, because we'll have additional guidance available to assist you on your submission of proposals to enable the department to have them in as much time as possible, to give them the consideration your proposals deserve and the department has committed to giving them, keeping in mind that the department wants to have the amended text to you 1 week prior to the start of the final session. So I thank you for your time. I thank you for listening. I'm going to turn it over to Brady to get you going and jump right back into changes of ownership. Brady?
All right, thank you, Cindy. And I am actually very quickly going to turn it back over to Greg. Greg, you just want to tee up exactly what we discussed at the conclusion of yesterday's meeting. I believe it was 600.4. Did we get to section G, or did we just talk about that first change in subparagraph A?
We well, G goes into 600.20, but we were talking about 600.4, and we were referencing the change in A, and this was where we had deleted the word private to match the statute in light of some confusion from a negotiator about what we meant there. And I think Donna had spoken to that a little bit before we had to break off for public comments. So I don't think we got to explore that completely. So there might be some more comments related to 600.4 A. And so I'd be willing to entertain those now, and then we can take a temperature check on that.
Sure. Anything new for the department to consider or to comment on for 604? Yes, Marvin.
Yeah, I had a colleague reach out trying to understand what the department is trying to convey there by changing private to other. And if it's just trying to match the regulatory language, I can circle back with them. But can you give us some insight, Greg?
Well, we changed it because there was some concern that what we had here did not match what was in statute. So that's why we changed the language. I think I don't know if Donna, did you have comments about that? You may have made them yesterday before we cut off, and you might want to reiterate.
This just tracks the statute.
Yeah.
The word private was put in there inadvertently. We were trying to track the statute language, and other tracks the statute language.
Thank you.
Okay, thank you. Anything else on 600.4? All right, not seeing anything. Vanessa, could you bring down the document? We'll take a quick temperature check on just this section, and then we will move on. With apologies, G does go into the next section. So we'll go to that next. But for 600.4, if I could just see the committee's thumbs. Jamie, would you mind? I'm not, oh, there we go. Okay, sorry. Didn't mean to rush you. Not seeing any thumbs down. Oh, and Ashley, I didn't see your thumb. I apologize. Okay, great. Not seeing any thumbs down. Thank you for that. Greg, I'll turn it back over to you and Vanessa for the next section.
Thank you. And Vanessa's going to queue up 600.20. And I know how you feel, Brady, with these numbers, and it starts to. I'm starting to see this in my sleep at night, you know.
Well, yeah, why don't we do G, because there's changes in G, and then we'll just stop at H.
Yeah, we'll stop. We'll just. I'm going to begin with G.
Until
so
H. Yeah. Okay.
We'll start with G here, and a couple of things with respect to G. We want to say that we appreciated the suggestion from a negotiator during our first session that the department consider charging fees to institutions for applications for changes in ownership. So we did take that back. We are continuing to assess what might be feasible in this area. So we do want to say that we have heard you there. We would ask here if anybody has any ideas for, you know, what type of a schedule would be for a appropriate fee schedule would be applicable for a change in ownership. So I do want to see if anybody has any comments about that particular suggestion. And I think Brad brought that up before, but if anybody wants to talk to that, I'll open the floor for that.
Any suggestions or comments to the department? Brad, yeah, please. And Vanessa, would you mind bringing down the document? Thank you.
Yes, we definitely would support some sort of fee structure if it led to the ability to know a time frame to be able to receive a response on a review. I think that's a good approach and one that we would definitely support. I have forgotten and I didn't come prepared with what that structure would look like. I think it was around like 0.15% of Title IV aid, but I need to confirm that. But I think we also proposed it being capped around 50 to 60K. So let me just write that to you.
Yeah, that's great. You can just put that in writing and give us some, if you have any ideas, or anybody else on the committee has ideas about that.
Yep, great. That's something though that I appreciate you all looking into.
Thank you.
Any additional considerations for the department on this matter? Johnson?
Yeah, just on the fee, having tried to understand high finance without an MBA, I have to think if the agencies inundated with such applications, they're going to have to outsource some of this, and that may cost quite a bit in terms of hiring consultants and so forth. So, I just want to say maybe 60 grand is about, a week's worth of work for some of the people, but I don't know.
Thanks. I'm not going to talk. I'm collecting comments. I can't really respond to these because I must be honest with you. I have no idea what would be a applicable fee structure. So we're just soliciting any ideas that you have that we can take back and look at. But thank you very much.
All right, appreciate it. Brad, please.
I'll just add to Johnson's comment. I support the department hiring more people to help them. So that would be good. That would help in the timeliness of the response, and maybe these fees could go to pay for some of their salaries. I hope they're not making $60,000 for one review though. But anyways, hire more people and the time frame will improve, I hope. Thank you.
Thanks.
Okay, Greg, I'm not seeing anything additional on G.
Okay.
So, and I'm just looking back at the document. It doesn't look like there's anything huge in H. Do you want to take?
No, we'll see. I have a couple more things in G to talk about, Bradley, before we get there. So I just wanted to, because that was a directed question, I wanted to get that out of the way. Some other things to look at here. We have updated. When we look at G1, Romanet 1, we have updated this suggestion to clarify that institutions must report any changes in their proposed new ownership structure at least 90 days prior to the change in ownership. This will help to ensure the department has final materials that will allow us to assess whether institutions will be prepared to submit a materially complete application shortly after the transaction. And here you can see that this is under 1, if a private not-for-profit institution or private for-profit institution or public institution participating undergoes a change in ownership, that results in a change of control. The secretary may continue the institution's participation in those programs if, and there you have, no later than 90 days prior to the change in ownership, the institution notifies the secretary of the proposed change on a fully completed form designated by the secretary and supported by state authorization and accrediting agency documents. So that is reflected there. And I want to draw people's attention to G2. We made some technical revisions here. We bumped out this paragraph rather than to make it a Romanet, and to update the cross references to the prior paragraph and change the word approved to continued, since this section refers to a continuation of participation in the Title IV programs. And we have also renumbered the next paragraph. So there you can see it was a Romanet, but has been changed to 2. So notwithstanding the submission of items required in paragraphs G1, Romanet 1 and 2 of this section, the secretary may determine that participation of the institution should not be continued following the change in ownership. And if we move over to 3, I'm going to go to Romanet 4. No, nothing there. No, I wanted to go to Romanet 5. I'm sorry. So we moved on to Romanet 5. At negotiator's suggestion, we have added language clarifying that the letter of credit may be based not just on the Title IV volume of the institution, but also other institutions under common ownership. if an entity in the new ownership structure has at least 50% interest in that institution. So let's look at 5. If deemed necessary by the secretary, financial protection in the amount of at least an additional 10% of the institution's prior year volume of Title IV aid, or a larger amount as determined by the secretary. If any entity in the new ownership structure holds a 50% or greater direct or indirect voting or equity interest in another institution or institutions, the final protection may also include the prior year volume of Title IV aid or a larger amount as determined by the secretary for all institutions under such common ownership. So that concludes everything that is for 600.20G. I'll open the floor for comments.
As I turn it over to the committee, I just want to welcome Carney King, who's here representing students and student loan borrowers. So welcome, Carney. Barmack, please.
So in 3 Romanettes, 4 and 5, I sound like a broken record, but the proper indexation is not to prior year's volume, but to the potential liabilities that the institution may have. And with regard to 5, I don't quite understand where the magic number 50% came from. I think the concern ought to be with significant overlapping ownership. It really doesn't need to be 50%. If you see there is a significant overlapping ownership, then other entities have to be pulled in my opinion. Thank you.
Okay, thank you, Barmack. Brad.
Yes, good morning. I just had 2 questions here on G1. I guess it was Romanet 1, but now it's been struck, which I believe are important for-profits, but also due to the increasing number of change of controls with nonprofits. I really think it covers us both here. But does this 90-day notice requirement mean that if a school elected not to pursue a pre-acquisition review, which is currently optional, would the Title IV eligibility be terminated and the change of ownership or control not considered for approval? It's the first question.
I'll refer that one to Donna. It's more operationally. I'll refer that over to her.
600 point, let me break it down, Brad. You're right, changes, pre-acquisition reviews of changes of ownership are not required. What we're trying to eliminate by this additional provision here in section 1 is to avoid fire drills. Because under the HEA and under 600.31, the school that undergoes a change of ownership loses eligibility unless it submits a materially complete application. What we're trying to what we're mandating now is that we get a heads up, that we know that when they change ownership within 10 days, they can actually meet those requirements. As opposed to what we're finding now is schools go through it and then they don't have financial statements, or they do not. Usually it's easy enough to get the accreditation and the state, licensing authorization documentation. It's the financial statements that are a problem. So this gives us a heads up, so we can send them a letter saying, this is what you must submit 10 days after 10 business days. Otherwise, you lose eligibility and you can't continue. The last Romanet, let's see. Did you move on to 2? Actually, number 2, or were you just talking about G1?
I was just talking about G1 at this point. So I guess the real question though that I was looking for is, if the 90-day notice is more on the termination of the Title IV eligibility, is what I was really looking for.
You must. This would be a prerequisite to going through your change of ownership.
Okay, so a prerequisite. So that helps. So then, if this is a prerequisite, So this 90-day notice, does it have to occur before then or any other pre-acquisition review application is filed? Because right now, I believe schools that are waiting well in excess of 90 days, often 6 to 12 months. The department is taking 6 to 12 months to process these pre-acquisition review applications now. So are we going to have to wait another 90 days before that process begins?
No, just as long as it's, no. It's not another 90-day period. So long as you don't change your deal, because that's another thing.
Okay.
We do pre-act and then they change their deal. And maybe different financials are necessary. So this doesn't add another 90-day cushion to it.
So this is just in addition to, if you
Yes.
still choose that pre-acquisition review is still optional.
Yes. This is protection more for the institutions that don't want to do a pre-acquisition review, that they at least give us a 90 days heads up.
Okay, interesting. Thank you. That's very helpful.
Thank you. I also want to welcome Dr. Adam Looney to our meeting, but Johnson, you are up next.
Okay, thank you. So going down to G2, G3, Romanet 5. So this says Carmack discussed about the 50% provision here of ownership. And the General Accounting Office, when they wrote this report it's either in 2020 or 2021 on scrutinizing changes in ownership of for-profit schools to nonprofit, they were using 35% ownership as a trigger for their analysis and their findings. So, it might be worth looking at that report because they were using a lower number. I think 50% seems pretty high. So that's one thing. And then with at the risk of really sounding like I've been asleep at the wheel during earlier parts of this, going back to the question Brad had asked earlier on, in G1, it says a private nonprofit institution, a private for-profit institution, and then it has the change of ownership or a public institution. Ownership's only applying to private for-profits, right? The nonprofits aren't owned by people, nor the publics. I know that's not language you guys created now. I just want to make sure I understand this.
If I can jump in, Greg. When you have a nonprofit, there's always some state entity that is set up on, it's a nonprofit. It's typically, it's a very rare event when this does not apply. And I can't even think of an event where it didn't apply. There is a state entity organized as a nonprofit under state law. What sometimes, and there aren't human shareholders, but you can also have in a lot of these entities a sole corporate member. For example, there'd be an entity set up under state law, and then there is another entity, a foundation, for example, that is the sole corporate member of that state law entity. If that foundation changes, we treat that as a change of ownership resulting in the change of control, because you could have completely different control at that point. So, yep, there aren't shareholders, but there is an ownership change.
That's very helpful. Thank you.
Thank you. Brad.
And I just had one other clarification type question in G3, Romanet 2, about the crediting association. So it says we added in a recently updated copy. And so I'm just really curious on the reason for adding the words recently updated. And I know it was in the first session, I just missed it. Does that mean that a school must ask its accrediting agency or state agency to update a new document that's outside of its normal processes? Because states and others typically issue licenses annually and do not issue interim updates. So I just want to make sure the latest issued document from the state would be what this is referencing.
We really want something more updated, because anything can happen. If you lose your license for some reason, if you lose your accreditation. And so, and we've had not a real big problem of getting these things. It could be a screenshot with a date. It could just be an email from the state authorizing agency. They're still in good standing. We have not had problems with having this be satisfied.
So an email from the accreditor satisfies the department
Yes. Yeah.
to go along with, I guess, the official license that was, done.
Yes.
And-
Because, some of these are for 3 years longer, so we need to make sure that there hasn't been a change. And the regulation says as of the day before. That has been the consistent language in this regulation. So we are getting stale documents, and this way it makes it clear we're not taking stale documents. This is not the approval. That doesn't come until later in H. This is just you are accredited, you have state authorization.
I mean, that makes sense. I agree with that, Donna. I just not sure if the word documents correct, but I'm fine with it. So we can move on. But
we've been flexible.
Okay, perfect. Thank you.
All right, thank you all. Greg, I'm not seeing any more hands, so do you want to take a check on the entirety of 600.20? The one other change.
That was,
So-
yeah, that's,
Okay, we can just do it. I only see one other modification in H, and it looks just to be numerical.
right, nothing new in H, so we can just do it on, so what we discussed was G, but that's the entirety of 600.20.
Right. Okay, if I could see the committee's thumbs on 600.20, changes in G. Thank you, everyone. I am not seeing any thumbs down. Feel free to correct me if I misspoke. But good, thank you for that discussion. Greg, I'll turn it back over to you for 600.221.
Thanks. So Vanessa's queuing up 600.21. This is updating application information. And we'll start with A6, Romanet 1. Here we have restructured reporting requirements to further clarify how they connect. Specifically, we've deleted paragraph 15 and moved it here into paragraph 6, Romanet 1. This says that institutions must report any change in ownership of at least 5%, ensuring far greater transparency. We have bumped the existing elements in 6 to a new Romanet 2, which explains which changes in ownership constitute a change in control. So the changes there in ownership that we see in 6 Romanet 1, changes in ownership. An eligible institution must report any change in the ownership of an institution that does not result in a change of control as described in 600.31 and subject to the requirements of 600.20 G and H, whereby a natural person or entity acquires at least 5% ownership interest, direct or indirect, in the institution. And our next change, if we go down to Romanet 2, D, here at the negotiator's suggestion, we have specified that this includes a director or other officer along with existing categories. So this is this includes the natural person becomes a general partner, managing member, chief executive officer, or chief financial officer, director, or other officer of the institution of an entity which has at least a 25% ownership or controlling interest in the institution, direct or indirect. And that those are all the changes for 600.21 A, and in fact, that's everything we have in 600.21. So I'll open the floor for discussion.
Great, thank you. Any new consideration or questions for the department on 600.21? Jamie.
Very simply renew the comment that I'm wondering why 5% was chosen and whether it might go too far in flooding the department with notifications that don't mean very much when Just wondering why that number was chosen, or whether it is really helpful to understand changes of control. I don't know what the source of the 5% level was, whether it keys to something where you just wanted something lower than what you had, which I can understand, but it seems a big, that it will generate a lot of notifications, and I wonder how you'll identify the important ones for that.
I think it's an awareness thing on our part to lower it to that, so that we're made aware of when these occur. And I can ask Donna if there was a why we set it on 5% exactly. I'm not 100% certain about that number, but I know that we wanted to make it more all-encompassing.
Seemed to be actually sort of an efficient number for us in terms of the kinds of changes that we're seeing. And what happens is we have these smaller changes, you know, in the delta between 25 and 15, that, you know, we can look at a situation a few years later. It's completely different than what's in the records, because what happens, particularly when they go through a change of ownership, we ask for pretty complete ownership information. And sometimes we're looking at structures that bear no relationship to what's in our records, because there have been different changes at lower levels. So it's really a record keeping mechanism. And I don't think in terms of how I've seen these transactions, that would be exceedingly burdensome for the department.
Thanks, Donna.
Thank you. Not seeing any more hands at this time. Greg, do we want to take a temperature check on 600.21?
Sure.
All right. Thank you, committee. If I could see your thumbs. I don't believe I'm seeing any thumbs down, but again, as always, if I'm misstating, please feel free to come off of mute and tell me, but no thumbs down on my screen. Thank you. And Greg, I believe, I'll turn it back over to you, but I think there's one other section with changes.
Yes, we're going into 600.31. Changes in ownership resulting in a change in control for private, nonprofit, private, or for-profit and public institutions. So you see section here A, we're going down to B. It's a rather lengthy section on definitions. So moving to oh, I'm sorry, we want to go to C. I'm sorry, we're going to go to C. Standards for there's nothing in B that has changed. Standards for identifying changes in ownership. And you'll see there that we have C1, C2, and then C3, which is other entities. So we'll start with this numbering is kind of convoluted, so I'll walk everybody through this. So we're in C3, other entities, and you can see here that they are identified by Romanet. So then you have Romanet 1, and then in Romanet 2, you have a series of letters starting with A, B, C, D, E, and then the first one we're going to reference here is F. There we go. And I was only able to do that because there were no I's, J's, or L's involved. So here we are at F. I'm sorry, I actually meant I meant G, not F. So in G, we have, in response to questions from negotiators, we have further clarified this language to explain that we are interested in the changing of a sole member of an owner of an institution, but are not looking to capture the circumstance of a sole member moving from 100 to 99%. So you can see there in G, notwithstanding its voting interests, a person becomes the sole member of a shareholder or limited liability company or other entity in which it has 100% or equivalent direct or indirect interest in the institution. The next change, we go down to Romanet 3, slightly below that, where it says the secretary deems the following interests to satisfy the 50% thresholds described above. And here in Romanet 3A, we have revised the language to capture informal agreements as proposed by a negotiator during session 1. So we'll take a look at that. And we're now in that's Romanet 3A. A combination of persons, although each with less than 50% voting or controlling interest in an entity, hold a combined voting interest of at least 50% as a result of proxy agreements, voting agreements, or other agreements, whether or not the agreement is set forth in a written document or by operation of state law. And that, I believe, is everything that we have. So we can go back and I'll open up the floor for discussion.
Okay, thank you, Greg. Committee, anything new for the department to consider on section 600.31? Barmack.
Sorry. This is with regard to C3. No, it's not new language for this round, but it is new language compared to current regs. And I just want to make sure that we are comfortable with the 50% threshold when applied to publicly traded entities. That just strikes me as a very high bar to clear. You can control a publicly traded entity with far less, even in combination, than 50% ownership.
I'll let Donna address that. She has some thoughts on that last time about the 50%.
We've got on a publicly traded, if you look at Romanet 2, it's at 25%. Okay.
Thank you for clarifying. And Greg, not seeing any additional hands, do we want to close out issue paper 5 with the temperature check on 631?
Yes.
All right. Thank you all. If I could see your thumbs for one final time on changes of ownership. Not on the whole document, just this section. It's the last section we're checking. All right. Not seeing any thumbs down. Thank you all for the discussion. Greg, do you want to jump right into issue paper number 7, the 90-10 rule?
Yeah, you know what? I'd like to take about 5 minutes.
5-minute break? Okay.
Yes, please, thank
Committee, I have 10:44 on my phone. If we could come back at 10:49, that would be great.
Thank you.
Thank you all. All right, welcome back, everyone. Hope you enjoyed the short break. Greg, I'm going to immediately turn it over to you to introduce 9010 and walk us through the department's changes for this round of discussion.
Thanks, Brady. So we'll be queuing up issue paper 7. This is Title IV Revenue and Non-Federal Education Assistance Funds 9010. And the statutory sites are there for you. Again, the regulatory site 34 CFR 668-28, and the change from Title IV to federal revenue reference there. What I'm going to do in this discussion is, because of the way that 668.28 is structured, I'm not going to discuss an entire. We're not going to go over an entire section before, or paragraph rather, before we discuss. I think I'll take it in smaller blocks as we go through. So I will probably change from what we've been doing over the past couple of days. So bear with me there. I just want to give people the opportunity to comment, because some of this is it's pretty complex, and I don't want to go too far before we give people the opportunity to discuss it. So we're going to start with in 668.28 A1, calculating the revenue percentage. And just as an introduction here, the proprietary institution meets the requirement in 668.14 B16. That's the reference in the program participation agreement, that at least 10% of its revenue is derived from sources other than federal funds, by using the formula in Appendix C of this subpart to calculate its revenue percentage for the latest complete fiscal year. And for purposes of this section, we move into Romanet 1, and we've made some changes here. Our edits in this section clarify that funds that go to the student directly should be counted, except for funds expressly designated for purposes that do not include tuition and fees. For programs administered by the VA that include housing benefits, those programs already provide tuition directly to the institution, which would be counted. We've also added the clause at the end of the paragraph to clarify expectations on the publication of the list of programs. So let's look at that then in Romanet 1. For any annual audit submission for a proprietary institutional fiscal year, beginning on or after January 1 of 2023, federal funds used to calculate the revenue percentage include Title IV HEA program funds and any other educational assistance funds provided by a federal agency directly to an institution or a student, including the federal portion of any grant funds provided by or administered by a non-federal agency, except for non-Title IV federal funds provided directly to the student to cover expenses other than tuition, fees, books, and supplies. The Secretary identifies the federal agency and other educational assistance funds provided by that agency in a notice published in the Federal Register, with updates to that list published as needed. And I do want to point out before I open the floor for discussion on this, that we are still working on preparing an updated Appendix C to reflect our changes here, but we will have that ready for you prior to the third session. So with that, I'll open it up for discussion, Brady.
Okay, just a few changes at the table to announce. Jalen is here on behalf of consumer and civil rights organizations. Travis is here on behalf of U.S. military service veterans, and Carney, I believe, is in for students and student loan borrowers. So welcome to the three of you. Why don't we just keep it to point number 1. Brad, please, you are up.
Well, before we start, can I add one thing, Brady? Steve Finley's back as our counsel.
Oh, okay. Welcome, Steve. Oh, and Emmanuel's here for private nonprofits. Sorry. All coming together. Brad, go away.
All good, sir. All right, so just real quick, because this is going to help my point throughout this issue paper, but when I was at TVA, a federally owned $9 billion utility company, the TVA executives would always get excited about their utility rates they charge customers being in the top quartile for lowest rates. My response would always be, why are we celebrating? We should be number 1 with the lowest rates, because all the competitors are paying taxes. Now I flipped into the world where about 10% of the students attend institutions that pay taxes and 90% attend institutions that do not pay taxes. Should be an immediate advantage right out of the gate if you do not have to pay 40% of your bottom line in state and federal taxes. But instead of the nonprofits lowering their tuition rates and investing in high demand programs they support, creating a rule that just puts their competitors out of business. The 90-10 rule has no indication of the quality of a school. And if you want that to have an actual impact, then it must be set up in a way we can administratively follow. I'll be pointing out various pieces of this rule that will prohibit schools from being able to actually perform this metric as it is intended. Also, the points we're discussing today may at best make up 0.1% of the funding categories at most proprietary institutions. So waiting on a book allowance stipend from the VA is not going to be the reason why a school fails 90-10, but it will be the reason why a school cannot ever accurately calculate their 90-10. I'll start with that, and then well, I can get back in line, but it doesn't look like there's anybody else in line.
Yeah, please continue.
Yeah. All right, so switch here. So on the actual let's see here. I'll start with why at the very end of what so I'm in 1 Romanet 1, and we say in the yellow edition, expenses other than tuition, fees, books, and supplies. I'll let you catch up, Greg, and give me a thumbs up when you're there.
Well, I'm there. Yeah, I'm looking at it.
Why did we put in the words books and supplies when right below in 3 Romanet 1, we say tuition fees and other institutional charges? As you know, most schools do not include books as part of their tuition and mandatory charges. You know, most students today are not buying their books at campus bookstores. I mean, Amazon is
30 seconds, Brad.
Amazon got their reason for their start was buying books. So how in the world can we as an institution know what students are paying for books? If anyone's ever been to a bookstore, there's 6 ways you can get a book today. You can rent a digital book, you can buy a digital book, you can rent a used book, you can buy a used book, you can rent a new book, you can buy a new book. Those are all different prices. So a chemistry book for a student, how in the world do we know what they pay for it, and why do we care if it's not on their ledger card?
In looking at what we're saying here, Brad, so what we're clarifying here is that we're actually allowing for those funds not to be included. So to go back to this again, so for purposes of this, so back to the STEM, at least 10% of the revenue derived from sources other than federal funds, and it's for purposes of this section, you know, for any annual audit submission, for a proprietary institutional fiscal year beginning on or after January 1, 2023, the federal funds used to calculate the revenue percentage will include. So at first we're saying include Title IV HEA funds and any other educational assistance funds provided by a federal agency directly to an institution or student, and including the federal portion of funds provided or administered by a federal agency. These would be funds to the student, except for the Title IV, non-Title IV rather, federal funds provided directly to the student to cover expenses and tuition other than books and supplies. So here I think this is a beneficial thing in that we're saying that those funds that are provided to students that are specifically to cover those expenses other than tuition fees, books, and supplies are not counted. So, you know, it's.
Steve, did you want to weigh in?
I just want to ask Brad a question for clarification, if that's okay. Brad, are you concerned that there might be an allowance paid to a student that would cover books and supplies, and we're talking about an institution that was not actually selling books and supplies to the student?
That is the concern, that the student's getting a book allowance through the GI Bill and then spending that allowance wherever they choose outside of the institution. I mean, we don't charge students for books. Students have the options freely to get books wherever they want to in the country. And frankly, we do a pretty good job of not requiring students to have to buy new published books that every year like the publics do. We actually make sure they're buying books that they can afford. So I'm not following this piece.
Yeah, we would entertain a suggestion to take a look at that to try to clarify the issue you're raising.
Okay, I'll submit. I think it just need to change it to institutional charges to delete books and supplies.
So is what you're saying, just to clarify, Brad, so you're saying, and this would be in instances where where the books and supplies are non-institutional charges, correct?
Yes, that's probably the case for most institutions. I don't know of many that charge them for it. So through the electric card. I mean, it's all off balance sheet.
So your suggestion would be to change that to institutional, to reference to institutional charges?
Yeah, as it's worded in 3 Romanet 1.
Okay, I think I understand what you're saying now.
Thank you. I want to give Dave just an opportunity to weigh in.
Yeah, I was just going to share that I think institutional charges is a standard term for 9010 right now, and this is a nuance. So if students pretty much need to buy their books or a kit or something like that through the school, it is included as an institutional charge. And that definition applies both in calculating 9010 and when calculating the R2, the refund calculation through the R2 T4. If schools have the option and they can go buy those books and supplies other places, they're not included as institutional expenses in 9010 or on the R2 T4 calculation. So I do think just using that's a standard defined term right now, I think.
Thank you. Steve, I also see your hand is up if you wanted to respond. Oh, you're muted right now.
I was just saying, I apologize. This isn't directly on point, but can you confirm that we're live on the public stream again? I've gotten a comment from someone that says they're seeing that we're still on break.
Oh, shoot. Patrick or Christian, could you confirm if we are live or not?
We are live.
Okay. They may need to reboot.
Okay.
Thank you.
Not a problem. Carney, please.
Yeah, I just wanted to respond to the books. I use the Chapter 31 GI Bill, the voc rehab benefits, and that goes directly to the school. I had to buy my books and supplies through the bookstore, and that even included my parking pass. All that stuff was all paid through a memorandum from the VA directly through the bookstore and university. So I don't think it's, I think it's more common than you would expect it to be that it goes directly through. Also, most people, sorry, my dog is right under me. Most people that were on the GI Bill that I, went to school with, and before I even used Chapter 31, we all went through the bookstore just because it was the easiest, quickest option. So I know a lot of the GI Bill funding is still buying books from the bookstore. So I'd recommend keeping that in.
I think I want to just point out that with reference to both these things, there are differences across different schools. There are reasons I don't want to go into it now, but with required proration of charges by payment period, why a lot of institutions have, I think, going back to Brad's point, have. I think you would find that recently that there's more of a transition to having those as non-institutional charges than maybe you saw in the past. But I think it does vary. In some cases, yes, you're right. Students are charged for all those, for tuition fees, books, and supplies when they sign an enrollment agreement, and it is all those are all institutional charges. And sometimes they're not. But I think it does vary, and we could look into accounting for both circumstances.
Thank you. Dave, did you want to respond?
I just wanted to confirm for Carney that in that situation, if the school is charging you and you're buying all of the books through the school, it is captured in 9010. So it becomes institutional charges that are included in 9010 and then also need to be incorporated when the R2T4 calculation is done.
So if I was just using Chapter 33 benefits where they just give me cash and tell me to buy books wherever, would that end up on there, or only if I'm like paying directly through the VA?
It would, well, there's a lot of nuance to this. So you have to determine what all the institutional charges are for the entire year. And then there's something called the presumptive rule, and you start assigning payments. So it's, you don't match up, okay, here was a charge and a payment came in, and you count that as either 90 or 10 money. And so I'm not trying to dodge your question, but it's not, you can't decide, okay, exactly this charge happened and then this payment occurred and it gets assigned to.
Yeah, I get it, because there's nothing connecting the student to, you know, just cash transactions at the bookstore or whatever, but.
Right.
Yeah.
Well, and it's also, it's not a timing so that, you know, I think rightfully so, you can't post tuition charges and have money come in that, you know, post money that meets the 10 first and say that's resolving charges, and then draw down the Title IV later on to say that's a stipend. So there's a priority of all the charges and all the payments for the entire year. And so what gets counted could actually change as you go through the 12-month period, again, because you have to look in the aggregate when it's done. And that's what makes it tough for any one transaction to consider it.
May I add one point to Carney's question? Is that okay?
Sure.
I also just want to mention that bookstore revenue does not count in 9010. So if, you know, buying whatever you buy at the bookstore, shirts, cups, whatever, that's not in 9010 either. Just clarifying that.
I do see you as also having your hand up next in the queue if you wanted to continue offering material for the subcommittee.
Yeah, no worries. Amanda was in front of me, but she may be good enough. So I had another question, same added language, where it says provided by or administered by a non-federal agency. So just pausing to make sure you catch up. This is troubling to me, and I'm assuming this is directed towards states and WIA funds. I'm assuming that's why it's just written this way. But if money is coming from the state, it shouldn't be federal money. And I understand they may contribute a portion of it, but let's think about this big picture. The states get a significant amount of funding every year for everything from the government. So at the end of the day, if it's a state payment, and we'll get into, I know there's a debate in 4 on how you apply it, maybe apply some portion to state and some portion to federal. That's coming up here in 4, which is going to be impossible for us to do. I just have a problem with the language right here that's saying a non-federal agency. The definition that Congress passed was it's a federal fund, and now we're saying money received from a non-federal agency counts against you. I'm struggling.
What we're saying is including the federal portion of any grant funds provided by or administered by a non-federal agency. So those would be federal funds. If that grant includes federal funds, then it's our position that they would be included in what the statute requires to be counted.
And you could argue every state grant has some portion of it that's federal, and I don't understand how in the world we can do this. But into the point in 4, and we're going to get into this debate at 4, and I'll save it for that, is there is no way we can go grant by grant by grant by grant, every single one of these that comes in and say 90% state, 10% federal. This one's 88% state, 12% federal. The next one's 75% state, 25% federal. That is going to be impossible. Anyone that's ever been in financial aid, and maybe Sam can speak to this, there is no way they're going to be able to do that. And it doesn't make sense to me to do that. And I'm sorry, that's if it's coming from the state, it should stay on the state side. Thank you.
Thank you. Jalen, you are up next.
Yeah, I think so. The comment that Brad is making, just for clarity, Greg, when it comes from the state, that's sort of speaking on like the foster care, or say, for instance, like I know the DMV, they give a tag to their students to assist with some of these institutional fees. Is that what we're clarifying, that that's what you are meaning in the sense of that is coming from the state as part of the 90/10?
What I think we're essentially getting at here is there are state grants that include a portion of federal money, and
Yeah,
so if that grant contains it does have federal money in it, then remember what we're talking. This is we're looking at federal, it's federal revenue. So that does become as opposed to it used to be just Title IV revenue. Now it's federal revenue, and that is revenue derived from a federal source.
I agree. I think that's the language is fine there. I support the language right there. Thank you.
And Greg, can I add one other point to that exact comment? So, stepping back on this whole thing, our financial aid compliance audit, a big component of that audit is the 90/10 calculation. And if you're off by a penny, it's an actual finding on that audit. This is going to set up Dave McClintock's and the firms of the world an opportunity to just hammer us on how did you come up with that pro rata breakdown? And every single state grant now, we're going to have to determine if any portion of that was federal. That's what we're trying to do here. This is nickeling and diming these schools that already have so much to deal with from a financial aid compliance perspective. I'm sorry, that is a burdensome task that nobody here should be expected to have to perform. Thank you.
Okay, Johnson, your hand is up next.
Yeah, I can't say I understand how the states report what portion of the support they're giving is federal, but I do see that I'm familiar with public benefits where the SSI recipients are told what percentage is being given by the state and what's coming from the feds. So, I mean, if people are reporting it and it's calculable that way, I mean, those things just come on a statement. All of my clients can see what's coming from the feds, what's coming from New York State. I think that's not burdensome. If it requires a lot of other analysis, maybe it is. I don't understand enough about it. If it's on a piece of paper, you should be able to calculate it.
Thank you, Johnson. Jamie.
I fully support the underlying objectives of 90/10. I am moved on this one to ask what the purpose of 90/10, to see whether this particular calculation issue maybe could be illuminated by thinking about the underlying purpose of 90/10, which in the simplest old-fashioned sense I have is to make sure that there are other decision makers choosing to support students in these programs, in addition to the federal programs that students can carry with them. And if the state is making the decision that it has a separate program where it controls the funding, even if the feds have contributed toward that stream of funding, I wonder if it might be appropriate for that, for the 10 to include the money that the state is directing and not require the accounting that Brad is describing. So, this is one case in which if we, where burden is necessary, we should require burdensome things if they're needed to get to the purpose. This may be one where the purpose that we're looking at really goes to whether the state is making a choice about the allocation of funds that it controls, whether it comes out of this year's budget or reserves or the Sunshine Fund or from a federal pass-through that the state gets to decide. This may be one place in which those comments are well taken.
Thank you.
Thank you, Jamie. Johnson, I have your hand is up next.
Yeah, I'm not quite sure I get my head around what Jamie is proposing, but to the extent that states are voting where good money is going, and whether they think with 90/10 designs that, that the marketplace is supposed to be driving decisions on what institutions are of value. I only know of one state that will not give state money to proprietary schools, and that's California. So the states are basically, the states that give grants, they're giving it to every type of institution, and it's a grant no different than a Title IV grant. And so if Jamie's proposing just count all the money, I think that's a fair thing to do, because there is no discerning pattern of whether you're going to get state aid. Your state aid is as long as the school is accredited and eligible for Title IV money, it doesn't matter what the institution is. So it is public money that's funding you.
I want to clarify here that our interest in this is federal money. So that obviously we don't want to count any state money toward that. I would welcome any comments if any of you are more familiar with state grants than perhaps I am. If you know how routinely those are broken down, the states with states informing publishing which percentage of their grants comes from what percentage of their grants comes from a federal source.
Steve, did you want to? I'll go Steve and then Dave. But did you want to speak on that, or was it a different point?
I was just going to echo what Greg said, which is our understanding is the federal portion of a lot of these state grants is readily ascertainable and does not vary from student to student.
And Dave.
Yeah, I don't know the size of the federal portion. I was just going to add, this might have been 15 years ago, I forget. There's a period of time where schools can utilize state grants as part of the SEOG match required. And there was a table that outlined how much of the state grant was a federal portion, and you could not include that in it. My recollection is, I see Greg and David nodding their heads, that they were pretty small percentages that were included. I mean, under 5% was my recollection. So there is a piece that's federal. It was not a significant portion, at least then. I don't know if it's changed since that time.
Brad, I see your hand. I just want to say that David is coming to the table to ask a question on behalf of state agencies. But Brad, take it away.
Yeah, I'll stay on this point because I know David will have a point on this, but there are many states that exclude for-profits from grants, and it is not, Steve, you're making it sound like to me that just because one grant may be easy to determine that the federal portion, that should be the case for everything, and it's not. At the end of the day, we're getting all kinds of grants from all kinds of different places, and we operate in all 50 states. And for the department to say it should not be hard to do and should be able to easily be calculated is just wrong. Until you live in a financial aid administrative place, you can't say that, and I'm sorry, this is going to be why we're not able to finish Title IV. This and if any money having to come from a VA is why we're not going to be able to finish Title IV on, or our 90/10 calculation on time. And I just completely against it.
Thank you. Jalen, I have your hand up next.
Yeah, I think I really just want to bring back the point that what we're trying to do here is prevent the gaming of the institutions from this matter. So I think what we're trying to say from our standpoint with this is that we brought this up to prevent any loopholes from occurring. So one, yeah, we closed the loophole, but now there's other loopholes that can possibly reopen. So with the Department of Education doing this, I actually agree with this. I think that there are some funds that do come from the federal government that are sent down to the state and that they can administer as far as funds from grants But when they are doing this, we have to take into account what percentage of that is being sent over to the school that the schools are using as deemable federal funds. I think that should be kept in mind here throughout the conversation. So again, like I said, I want to reiterate that we do support this because we think that, like the foster care program, students leaving out of the foster care system are able to go to institutions where they actually have programs set up for them to attend when they age out. But we need to make sure that that funds are included in the 10 and not the 90.
Thank you. David, welcome. Please go ahead.
I was just going to say that the document that Dave mentioned in terms of showing that percentage of state money that's blended in with federal funds for grants that states give out, that's created because the states are required to very strictly do cost accounting under OMB Circular A87. And so the state can easily tell everyone, the public, exactly what percentage of a WIOA grant or some community development block grant or other funds that the state has. If they blend that with some of their own state money, they can say what percentage, because they have to in order to report back to the federal agency, Labor Department or Health and Human Services or whoever gave them that money. And so I think that there might be a way to write this to say, to the extent that the state does the cost accounting, so you put this on the state, not the school. I mean, I hear what's being said about financial aid offices being burdened with having to go forensically find this out, but the state could very easily tell for the vast majority of cost accounted under OMB Circular A87 grants, what percentage was their money and what percentage came from a federal agency.
Thank you, David. Brad, your hand is up next.
Thank you, David. I don't have any other comments on that particular piece, but I do see Debbie just raised her hand, so maybe I'll get behind her if she wants to speak to the state issue, and then I've got one other comment in Romanet I.
Sure. Debbie, welcome back on behalf of state agencies. Take it away.
Thank you. I actually really appreciate David's comment about whether there's a place where there's a role there for the state to take on some of this burden, because I do think that the kind of the workability of the rule is important. And I wondered if the department has a sense of what would be on this list now. I mean, are we talking about a dozen programs? Are we talking about 100? I'm just trying to get a sense of what that would look like.
As to how many of these there are. I don't know that we've identified that number. I mean, the regulation's meant to be inclusive of them. I think that primarily it would be state grant that we would be concerned with here, but the reg is written to include any type of assistance funds that would include a federal portion. So I don't know. I can answer exactly that we have a number for that.
Okay, Brad, take it away.
Thank you. Yeah, my last comment, it's maybe my skeptical nature, but you can argue that any state grant, if they're getting any money from the federal government, could end up being some percentage federal. And I'm not talking I'm talking like Tennessee student assistant grants that come directly from the state budget, but some of the state budget is funded from the federal. So again, my skeptical hat. So Federal Register, my next comment here is the very last sentence of basically Federal Register with updates to that list as needed. I appreciate the added language. I did request that. I still struggle though, if you're in the middle of your fiscal year and a new federal fund source gets added, like we'll just call it HERF funding. It all happened to us in COVID. We all got HERF funding. If that came in the middle of our fiscal year, then all of a sudden that's determined to have met this rule. All those funds that were dispersed prior to knowing that would then hit your 90-10. And so you could be on the last day of your fiscal year, you find out that some fund source all year you didn't think was federal now has been deemed federal. So I do think we need to have a list that's regularly updated. And again, I appreciate the language, but I do think it needs to be tied. It's whatever the list is at the start of your fiscal year, that's the list. And or if you're going to add something in the middle of the fiscal year, it's added before the funds from that fund source type, like a HERF, it's known that those funds are federal. So I mean, we just need to know, I guess is the point. And you know, but I appreciate the language that's added.
I'll take that point, Brad, and I think we do need to look. We can go back and look at what the how. I think that's a very legitimate question. How it would implement when I suppose when the Federal Register is published, what sources are on there, and when the school is responsible for knowing those, especially if it's if the publication of that register falls in the middle of a fiscal year. So we'll take that back for discussion.
Okay, thank you. Marvin, I have your hand is up next.
So I've never worked at a proprietary school, and I don't know if there's already a carve out, but I just point out that like campus-based aid is a federal aid program, but 25% of the funds come from the institution. So is that already being accounted for and excluded in the 90-10 calculation? Because
it's in it. Federal work study money's in it. It's in the 90. It's in the federal.
This sets up an exclusion, doesn't it? The way it's worded, that 25% of the funds come from non-federal funds.
Yeah, institutional funds don't count. But Dave, you take it.
Yeah. Dave, do you want to weigh in?
Yeah, right now only the federal portion of SEOG is included in 90-10, and the 75 counts to 25 does not. And it doesn't get included either way because it's not, if it's through the institution, it's not outside money.
Okay, thank you. Travis, please.
Yeah, thank you. On the Federal Register point, I just want to advocate for adding specific agencies that the Department of Education knows is already big spenders, like Department of Defense and VA. I don't think we should rely on the Federal Register being updated continuously, or if it's missed or something in the future. I know that I think you guys said that you're working on that, but I just want to point that out that we would like specifically added those mentioned in there. Thanks.
Thank you. I think the intention would be to publish a Federal Register that would include, say, so at least initially anyway. Of course, the largest sources would be VA and DoD. Those would be on there, and there would be published updates as needed. But that for instance, let's use VA and DoD, they would roll forward, so you would know that from the very get-go, and that would be we would publish that early, and it would be. Hopefully, we would have one of these out before the regulation took effect. So that would be there, and if we needed to update, we'd be adding to that list as we updated.
Okay, so things wouldn't be able to be removed like in the future, or it would just be continuously added?
I could imagine. It may be that there are sources that would get removed if those sources were no longer providing this type of assistance. I can't imagine that the major ones, VA and DoD, would ever occur.
Right. Okay. Thank you.
Brad, please.
Sorry, I'm trying to type in the chat what my proposed language is, but I just want to say I do support Travis's comment there that VA should be included. I think that's good.
Thank you. Not seeing any new hands, Greg, I'll turn it back over to you.
Okay, yeah, I do want to say that we're aware of the point that Brad made earlier about institutional charges versus books and supplies. So we'll definitely take that back. So yes, that's the only thing I wanted to say. If there are no more comments or discussion, we can move on to, we could take a temperature check just for
Did you just want to do number one?
A1, yeah, for A1. Why don't we do that?
Before we do that, Amanda, I do see your hand is up. Did you want to speak on that?
Sorry, I just have one question to the education department. So are you saying that never in the calculation of 90/10, books were never included in that calculation because any books, there's no contracts with institutions, with professors and their books, or there's now we have now there's like access codes to like online books where there's, are you saying that they're like, the education department is saying that books were never included, and are they unaware that potentially institutions make contracts with professors and the bookstores so that they do receive a portion of those funds or access codes provided to students? Like, is that what you're saying? That you do not see that as institutional, students providing institutions funds?
No, what we're talking about here is the federal funds, is the federal funds that go to pay for institutional charges, and was explained by some of the other negotiators, I think David and also Brad, that books and supplies can be an institutional charge or not. So if it's an institutional charge, that means that would be a situation where the institution would require these students to purchase the books from the institution. So generally, when that happens, there's some type of an enrollment agreement whereby the institution, the student signs that and is liable for, owes that certain amount of money, and then that would be revenue to the school. Where in situations where it's just where it would be usually always is the case with your more traditional, college and university, where you just go purchase the books on your own. You have a bookstore, but you can purchase them. It doesn't have to do with whether you're required to purchase the book that's written by a certain professor. We've all been down that path. But it has to do with how the books and supplies are charged. Are they part of the charges that you pay at your institution? And in most, what you're familiar with probably is that you could purchase the books at the bookstore, and you were allowed to charge them to your account at the school. But that's not the same thing as the school requiring you to do that. So that's the difference we're talking about here. And when Brad raised that point, he was talking about the situation that is increasingly the case at proprietary schools as well, where books and supplies are not part of institutional charges, so they're not lumped in with tuition and fees. I hope that answers your question.
Sorry, can I respond to that? And maybe this is an emerging issue, and maybe people aren't really understanding what's happening, but and I understand in conflict, probably also hard to administer, try to catch what books are actually, yes, maybe in contract to an institution, we did not say as a student, we're forced to buy these books, but technically by proxy, nowadays, especially with online education, you cannot complete your homework assignments without an electronic access code. And especially with online, most students have now been going to online school. I assume, I don't have the data to back this up. I don't really like to speak about things without data to back it up, but I know from anecdotes and also from my own personal experience, yes, I did not sign a contract with the institution that I would have to buy that access code, but if I did not buy that access code, I could not finish my coursework. And that was mandated and required by the course that I signed up with. So yes, maybe this can't be solved today in this specific regulation, but I do want to bring up one, demystify and counter arguments that institutions are not requiring you to buy books or other things through the bookstores, but there is this emerging issue, and I would say it's prevalent now, that students are required to finish their courses through online access codes that they can't get through Amazon or these other ways. Online, there are online barriers, and there are, I would say, books are now becoming a more, I would say like online courses or online books is a problem, and students aren't paying it towards other outsourced resources. It's directly within institutions or whoever they contracted with.
I certainly.
But I get this is a new issue. I just want the education department and people to be aware of this issue, and it's going to be prevalent. And maybe we can't solve it today, but it's a necessary thing for college affordability, especially with this as well. That needs to be solved potentially in the future.
Yeah, I think point's well taken. I think that there are a lot of, certainly with increased use of these types of codes and whatever. But I want to point out that, and it's important to remember here, that the 90-10 rule applies only to proprietary institutions. So we're not talking about the general, what you might be familiar with, where the college university used to go to the bookstore, now they have these access codes. Which is not to say it's not a problem. I do think that it could be a problem. We do say that our guidance has been that any institution where the student does not have a real and reasonable opportunity to purchase books and supplies from another source, that charges do become institutional. So I do want to point that out. But I think the issue you're pointing out here is a very important one, but sort of is much larger, goes beyond what we're addressing here with 90-10. I don't want to belittle it at all, because it certainly is increasingly I think an issue for students where, it used to be you could buy the books from the used books or whatever, from the used book exchange, and maybe save a little money, but where you have to purchase those codes, that doesn't become possible anymore. So I take your point. Thank you.
Thank you. Jalen, feel free to speak, but is it on what we're about to take a temperature check on?
Yeah, and it was just sort of to what Amanda had just alluded to, and even Johnson's comment here. If you look at it now, and I know Brad will say that this isn't like Greg just said, it's proprietary schools. They have a required courses that you have to take. You have to purchase certain books and stuff from that actual bookstore. But at traditional universities, they're also not requiring that. And I think what we need to also take an eye at and look at from the Department of Education can hopefully look into is the requirements when the account hits the ledger of students' accounts after they refund the money. Say the student doesn't purchase from the bookstore. Is that still going to be considered part of the 10, or is that considered part of the 90 as well?
Well, those are usually funds which are above and beyond the institutional charges that are given to students for living expenses, and those don't count. Those don't count in the calculation. Those are not held against institutions. It's only the revenue. It's only tuition and it's only the up to institutional charges.
I think.
Does that trying to answer your question there? But yeah. And in the case where you can see we don't have it here in front of us, but when you look at the way that it's actually calculated, which appears in Appendix C. If we had this, it would probably make more sense. But when you do the actual calculation itself, you look at Title IV revenue, which is adjusted, and you look at adjusted student in the numerator, and then you look at adjusted student Title IV revenue. And so there are adjustments to those amounts, and the amount of aid above institutional charges is an adjustment. I will let I know that Mr. McClintock does have a lot of experience in this, and maybe he has a more direct way of describing what I just described. So I'll ask David if he wants to take a shot at that.
I don't know if it's more direct, but I could try. So again, part of what I talked about before was where you don't use the definition books in this is the qualifier is institutional charges get included in 9010. And at a school, if you are required to buy the books or kits from the school, you don't have access to go buy them somewhere else, then they are defined as an institutional charge and they are included in the 9010 calculation. If you're attending a school where you do have the opportunity, you can buy it through the school or you can find other places that might be cheaper to buy the books, then they're not included as an institutional charge. So books are not always or never, it depends.
And that was my question right there, Dave, because we all have the professor that, you know, they get cut a nice check because they wrote the book and they say, hey, I need you to go and it's required that you read this book as part of the course. So that was my question right there, but thank you. And then Greg, do you know when we'll be able to get the Appendix C out so that we can review it before the
Yeah, well, we will have Appendix C for you before the next meeting we have in March. And yeah, Appendix C does help. Appendix C is shows you, as David McClintock pointed out earlier, that the calculation is done on a student-by-student basis and then aggregated. So with the appendix, you can, and I can, you know, if anybody wants to look at it, it is in the current regulations now. It's Appendix C to Subpart B, I believe. Someone correct me if I'm wrong. Appendix C to Subpart B. You can pull that up on. You could just get that on. You can just Google it, the Subpart B of Part 668. It would show you how the appendix works. But yeah, with respect to the books and supplies, the other thing I want to point out too is that 9010, the rules are written, of course, with changes that have occurred over the past number of years, there are a lot of for-profit institutions that offer, you know, 4-year programs, whatever. So it's not quite as maybe homogeneous as it was at one time, but the whole tuition fees, institutional charges thing with respect to proprietary education, it generally went back to the way it always used to be, was that it was if the books and supplies were included, and in the past they were more often. I think that Brad's right to point out that increasingly that's not the case, but it used to be that they were all included in a enrollment agreement the students signed. So when the students signed for a certain amount of money, it included tuition fees, books, and supplies. So from the standpoint of auditing it or calculating it, it was probably a lot simpler than perhaps it is now. I know that's probably confusing, but I just.
Thank you for the exchange. Are we still okay to take a temperature check just on number 1 right now?
Yes, yeah, let's do that.
Okay. Could I see the committee's thumbs? I see 1 thumb down. If I missed anyone, let me know. And then, Brad, anything new you'd like the department to consider on section 1?
Yeah, I submitted my language in the chat, and I just to Jalen and Amanda's earlier points, I fully understand your concerns, and I also fully support not requiring students to have to buy books from their own professors. Thank you.
Thank you. All right, Greg, are we ready for section, or number 2 rather?
Yes, we are ready for number 2. I think we all remember the buying the books from the professors. I do want us to commiserate on that, because I had a couple who thought their books were the be all and end all, and certainly we're not. Okay, so we're looking here at in number 2, which is a disbursement rule. Formerly it was cash accounting, so an institution must use the cash basis of accounting in calculating its revenue percentage, and the edits here in this section clarify the language and specify that we are including federal funds used to pay tuition and other institutional charges. So here, again, we do reference institutional charges. And let's look at Romanet 1. For each eligible student, counting the amount of federal funds, should go up to the top rather, institution must use the cash basis of accounting in calculating its revenue percentage by, for each eligible student, counting the amount of federal funds that were used to pay tuition fees and other institutional charges the institution received during its fiscal year. And if we go down to Romanet 2, their edits in this section clarify the language and specify that we are including Title IV funds used to pay tuition fees, institutional charges again. So down here we have for each eligible student, calculate the amount of Title IV HEA program funds the institution received to pay tuition fees and other institutional charges during the fiscal year. However, point that out. However, before the end of its fiscal year, the institution must request funds under the advanced payment method in 668.162B2 or the heightened cash monitoring method in 668.162D1 that the students are eligible to receive and make any disbursements to those students by the end of the fiscal year. And here we have, and then below that in B, for institutions under reimbursement or heightened cash monitoring methods in 668.162C or D, must make disbursements to those students by the end of the fiscal year and report as federal funds in the revenue calculations the funds those students are eligible to receive before requesting funds. So we've reordered the sentence to clarify our intent. The sentence, as we just saw, now begins with the reference to reimbursement or HCM1 payments. And I will stop there for comments since that's a pretty significant regulation.
Okay, thank you. Brad, take us away.
To start, I'm okay with the changed language, but I do want to repeat a concern, and I just really am struggling with Romanet 2A. And so we have to request funds that the student are eligible to receive and make any disbursements to those students by the end of the fiscal year. Operationally, let me just describe something that's true at my institution. We've got about 6,000 students that will start a semester right before the end of a fiscal year, right? So fiscal year is 9/30. We may have a start on September 25th. Students may be eligible to receive those funds on September 25th, but for me to get 6,500 or 6,000 students paid in 5 days just is administratively not feasible. And it's just not worded in a way that I'm comfortable with. I mean, for us, our institution, we don't even truly, we require students to get to a census date, which is 2 weeks after the start before they're ever, I guess, charged. Or I guess, before they ever owe any money, I guess would be the best way to say it. And so, you know, the census date support. So again, I'm just struggling with how in the world, and maybe Sam could better describe it, how in the world we can comply with A as written. Because I read it as any student that's eligible, regardless if your quarter starts on the or semester starts on the very last day of your fiscal year, has to receive those funds by the end of the fiscal year. I just don't see that's possible.
Going back to what the reason why we did this, again, I think it's relatively apparent why we did it, because just to remind or to reiterate that 90/10 is done on the cash basis of accounting, so it is possible for institutions to and I'm by no means suggesting every institution does this, but we have seen it where they essentially circumvent or game the calculation by since it is cash based, by delaying a drawdown of funds in one fiscal year and moving it to another, which can have serious consequences if the institution failed in a previous year and was like to fail again. Then they could avoid that by simply not having that money count as federal revenue in the fiscal year for which would cause the institution to fail by bucking it forward into the next year. So it's a serious concern we have that we feel a loophole that we feel needs to be addressed. I do understand your point, Brad, that there could be situations where your disbursements are occurring or your start of a new payment period falls directly right at the time of the end of the fiscal year, and where it might be difficult for the institution to make those disbursements prior to or draw the cash rather actually prior to that point. But if you want to provide language that you think would put some parameters around that or account for those situations, we'd be happy to take a look at it. But we're pretty resolved with the rule because we feel it's necessary to prevent a situation where institutions are avoiding the consequences of 90/10.
Greg, I fully respect that comment and loophole. I proposed initially to strike it all. Maybe I can work on some language there that helps. My concern is everyone, and when you start a new term, everyone becomes eligible on day one. And you can't get everyone paid on day one. It just feasibly is not possible. Anybody that's ever worked in G5 tell you it's not an easy process. And so I hear you. I just think it's set up right now that, and I don't know how an auditor could even audit this, but I read it as on day one, you have to give everybody that's eligible, which is everybody attending your institution, funds on day one. And you just can't do that the way the G5 federal system works today.
Well, I don't think we're saying on day one. I mean, we're saying, this has to do with going over fiscal years. So for each eligible, right, when they're eligible, however, before the end, for each eligible student counting the amount of Title IV HEA funds the institution received to pay tuition fees, other institutional charges during the fiscal year. However, before the end of the fiscal year, the institution must request those funds. So it has to do with getting those funds requested before the end of the fiscal year, not issuing a specific day. Of course, if the fiscal year does fall at a certain point, it may effectively put you into that situation. I agree there, but which is why I would say that if you have language you think could assist with that, we'd be happy to take a look at it. Yeah, Steve, do you have any comments you want to make, Steve? I didn't know if your hand was up.
No, I understand what Brad's describing, and I would like to see suggestions he had that we could discuss within the department.
Yeah, Greg, and I've just thrown this out there. I mean, to me, the 30-day is already a metric that's used for HCM1 for new students. I don't know. I'll work on something there, Greg, but it just, to me, I read when you say eligible, that to me says first day of the term, and that's where I'm struggling. So thank you though for listening.
Dave, did you want to weigh in on this exchange?
Just to share what Brad mentioned about the audit, and he mentioned before that as an auditor, you're required to report anything as a finding if the 90/10 is incorrect. And so the way this is set up, it would be pretty difficult to determine what should have been drawn down with drop ads and verification. I understand the difficulty in defining this. I understand what you're trying to stop, but also there's just G5 and there's verifications and lots of moving parts. And so without a definition, it would be tough to state whether they were following this and complying with the any difference needs to be disclosed aspect of it.
David, I'd invite you as well if you have any suggestions for language to submit that to us.
Okay, thank you. Johnson, I have your hand up next.
Yeah, just briefly, I support the department to the extent they're trying to stop gaming. There's a recent report that ITT Tech changing their zip codes to avoid gainful employment and that sort of stuff. On the other hand, I am sympathetic with Brad's position, and also don't want students to incur institutional debt because there's been disbursements before they could drop a class without any consequence. So I do think there needs to be some getting together on this to make sure it's doable. So.
Thank you. Debbie, you're up next with your comment noted in chat. Thank you for that.
So with regards to this point, I think in the last session, there was an idea thrown out that funds could be included in the calculation for a fiscal year if they were eligible to be dispersed to students, whether or not they were in fact dispersed. So it seems like that would get to the department's goals, but also solve for the administrative issues that Brad was mentioning. So I'm wondering if that's something the department considered.
Yeah, we did. I mean, there's an issue here dispersed, and I think, and actually the funds requested, and part of where we are is because 9010 is this odd duck with the requirement for cash accounting, and most everybody who's, well, unless, if you've had the standard accounting classes that most people take, one or two, you're really all you've ever dealt with is accrual accounting, and that's what's hammered into your head, right? And so we do require, disbursement. We do have disbursement rules, and that has to do with when an institution credits a student's account with Title IV funds or their own funds. When a student has made disbursement, is received disbursement. But with 9010, it becomes important when the school, and really this is really unique to 9010. It becomes very important when the school actually drew the money down. Normally, I don't say we don't care. We want schools to draw money, but there are plenty of institutions that, especially large publics, sometimes will wait for quite some time to draw their funds down to cover disbursements. It's very common. But it doesn't really make much difference in that world. Here it does, because it has to do with when they actually, not just the disbursement, but when they actually draw the cash, go into G5, as I think Brad referenced G5, the mechanism through which you actually go request the funds. So when they get the funds, that's when they're counted under cash basis. So yes, we did explore that language with if the disbursement was made, counting it as or sort of saying that it would be the same as if it were received, but there are issues there with respect to cash basis of accounting. So that's why we did it the way we did, but we certainly take that comment back.
Thank you for that. It's very helpful.
Thank you. Brad, I think you are our final comment before lunch, so take it away.
Yeah, just to add to Debbie's comment, it is when it's not when we request the funds from G5, it's actually when we receive the funds into our bank account. But once we receive the funds, we have 3 days to issue the stipend. And in instances, we encourage students to sign up for ACHs because that's the easiest way to send students their money. But we're unfortunately, I don't know if it's fortunately or not, but students can still get checks. And so that does take a little time to process. And so that's why there's a 3-day rule there. But for 9010, if we requested money on September 28th and received it on September 30th, it would count for 9010 purposes for the 9010 score, but then we would have still 3 days from the 30th to actually get the check or ACH in the student's hand. And that's how it kind of works. But when we send the money to the student, it does not impact 9010.
Okay, thank you. Not to get out over my skis, Greg, but I'm not seeing any new hands. Do we want to take a temperature check on 2 and then start with a new section after lunch?
Yeah, we can do that, certainly.
Great, okay. So thank you all for that, committee. If I could just see your hands on section 2 of this. Ashley, if you wouldn't mind, thank you so much. I'm seeing 1 thumb down. Brett, anything new for the department to consider on section 2?
We'll work on language with the department. Okay. I think we both mutually agree on this.
Thank you so much. All right.
Thank you.
Thank you all for your hard work this section. I know this morning session, it was a lot. You have an hour for lunch, and we will see you at the top of the hour, 1 p.m. Eastern. Enjoy. Thank you.